It's time for you guys to start being journalists.
Before an angry Andrew Baldwin left the courthouse, 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."
Alright guys, so the disaster that is the Delphi case continues. The executive director of the Indiana Public Defender Council has now issued a document to the Supreme Court of Indiana expressing her disdain at what has been going on. You know the story. If you're watching this video, you know the story by now. And we're going to read parts of that document in a moment. I'm guessing you may have already seen it because it came out yesterday. And you know what, guys? I was just too tired. I had a busy day. I was just too tired to do a live stream last night. So, yeah, lots of you will have already seen this. But I'm sure that you want my opinion, don't you? I think you should get my opinion, okay? I think that's the least I can do. All right, so those of you who think that what Judge Francis Gull did was okay, you are sadly mistaken. You have not been listening. You've just been assuming that because I've been saying that this is a disaster for the case, but not only that, not only does it delay any justice, it just disregards Abby and Libby's families, and also the rights of Richard Allen. You assume that I think Richard's innocent, and I'm picking on the judge, and I'm making stuff up about the judge, saying this is a dangerous precedent for everyone who lives in civilized society. You're not taking it seriously, and what you're doing is assuming that I'm biased, but actually it's you that's biased. You see, the thing is, it doesn't matter. At this point, at this moment in the case, it doesn't matter whether Richard Allen is guilty or not. It doesn't. As I keep saying, this is about due process. I don't know whether Richard Allen did it. I can have an opinion. I don't know. But what I do know, absolutely 100%, is that the judge has not followed due process. And it's all very well that Andrew Baldwin and Brad Rosie issue affidavits and explain what happened, or David Hennessy, who is Andrew Baldwin's attorney, puts out a document with the law. You're still going to think, well, that's a bias, that's a person trying to get back their job, or a person who just feels wronged. But no, objectively, this is wrong. Objectively, due process has not been followed. And if due process is not followed in any case, there's no justice. All right, so what is this document? Let's get to it. All right, so this is filed to the Indiana Supreme Court, State of Indiana, on relation of Richard Allen. So this is another couple of attorneys acting on behalf of Richard Allen. Richard Allen is the relator or realtor, I don't know. And this is versus the Carroll Circuit Court and the Dishonourable Francis C. Gull. And this is a brief of amicus in support of the relator's petition for writ of mandamus. So this is someone called Bernice CHORLEY, who is the Executive Director of Indiana Public Defender Council. The Executive Director, the boss, has now weighed in. Well, David Hennessy did say, or was it Andrew Baldwin? Anyway, someone from his camp did say that if they're being given due and proper notice of a hearing to disqualify, instead of just some emails and then some clandestine meeting in chambers that they can't even get the transcript of, even though the court reporter was in the room. It was on the record. If they'd been given due notice, as they should have been, they would have brought witnesses. They could have brought people from the Indiana Public Defender Council. So the chances are Bernice would have been one of their witnesses. But instead, she's written this document in support of Richard Allen's case to the Supreme Court of Indiana, and also an attorney called Joel M. Shum. The Indiana Public Defenders Council's mission is to improve legal representation provided at public expense in Indiana state courts. The mission is fulfilled in part by providing research, training and consultation on strategy and tactics. So, IPDC is also mandated to assist in the coordination of the duties of attorneys engaged in the defence of indigents, so people who can't afford their own private counsel, at public expense, and maintain liaison contact with study commissions, organisations and agencies of all branches of local, state and federal government that will benefit criminal defence as part of the fair administration of justice in Indiana. So it goes on to say they're well positioned to address this the importance of independence of defence function. Independent meaning that a client of an attorney, right, a defendant, has the right under the Sixth Amendment to have counsel, but that counsel should be one of their choice, and that's regardless of whether this is a public defender or a private counsel. I know it's a little bit more difficult with a public defender because, you know, you're allocated one and you're pretty much stuck with it. But in this case, highly unusual case of a judge disqualifying two attorneys for gross negligence when no proof of gross negligence has ever been issued on the record at all, end of story, then these guys are well positioned to deal with it. All right. Okay. So raising concerns about the removal of his court-appointed counsel. However, this brief intentionally focuses narrowly on the independence concern, so they're hammering in on one specific issue. And it's that one specific issue, well, one of the specific issues that I've been banging on about, that this is setting, if it is allowed to proceed and she gets her way, it's a dangerous precedent for anybody accused of a crime in the good state of Indiana, or in the good nation of the United States of America, or indeed anywhere in civilized societies. It could be you, it could be me, it could be anybody that you care about in the future, that the judge just comes along, makes some stuff up based on next to nothing and says, gross negligence, you're off. And not only is that the judge saying that, but also the prosecutor. It's the prosecutor's idea. Where's the independence? No, that can't be allowed to continue. Okay, so they go on to highlight that Indiana has long been a leader in providing appointing counsel for Allen County, especially the chief public defender of that county, deprives Indiana's third largest county of the leader of its public defender's office, and raises the prospect of loss of reimbursement for Allen County. Okay, so it's bad for Carroll County because, oh dear, she didn't even follow due process, not only in disqualifying Baldwin and Rosie, she also didn't follow due process in appointing Scremin and Labrato. They're not on the list of the Carroll County Plan of qualified attorneys approved by the county's public defender board. She just chose two people who are her friends. People have been laughing and saying, Michelle, you're just so biased. No. She appointed her friends. They're not approved by Carroll County. Okay. The removal or replacement of appointed counsel must occur in a manner that ensures the independence of Defence Counsel. So, this organisation is also concerned that the removal does not undermine the public defender structure in both Carroll and Allen counties. So they go on to cite some legal stuff here. Okay. Right. The American Bar Association, among other groups, has long emphasised the critical importance of public defender independence. The first of the ABA's 10 principles of a public defender delivery system, which provides guidance on how to create a well-functioning and constitutionally sound public defence system, is that the public defence function, including the selection, funding and payment of defence counsel, be independent. Okay, more law. Right. As noted in this case here, trial courts retain some ability to appoint counsel outside of a county's comprehensive plan in limited circumstances. Appointments outside of the approved plan, and this was outside of the approved plan for Carroll County, may affect the ability to seek reimbursement from the Commission. First, under Indiana Code 334710A, a judge may appoint counsel outside of the plan when the interests of justice require. So she's going to argue that, isn't she? But did she even try to remedy it in any other way? No, she didn't. No, she didn't. A court may also appoint counsel to assist counsel provided for under the board's plan of core counsel when the interests of justice require. However, expenditures outside of the plan are not subject to reimbursement from the Public Defence Fund. So she's costing Carroll County a bunch of money here. Right, okay. But it's that's just one issue. That's one issue. The ABA's 10 principles have been updated since the court decided Johnson. They now provide that public defenders should be subject to judicial authority and review only in the same manner and to the same extent as retained counsel and the prosecuting agency and its lawyers. Okay, so was that even considered by her? No. Okay, all right, we'll read this. Counsel was replaced without regard to Carroll County's comprehensive plan. The independence concerns raised by removing appointed counsel are exacerbated when the process for selection of replacement counsel fails to follow the statutes and structures designed to protect the independence of defence counsel. Carroll County is a member of the Public Defender Commission and has Public Defender Board and Comprehensive Plan. The Commissioners of Carroll County adopted an ordinance creating a Public Defender Board in 2000. The county's plan provides for an assigned counsel system. Okay, so the board shall gather and maintain a list of attorneys qualified to represent indigent defendants. Upon the determination by a court that a person is indigent and entitled to legal representation at public expense, the court shall appoint an attorney to provide the representation from a list maintained by the board. So she didn't do that. She didn't bother with that. Okay, she didn't need to because she's just the boss. She's just the boss of the world. She didn't need to. Okay. Here it's unclear why the respondent appointed counsel in a manner inconsistent with Carroll County's comprehensive plan because she thought she could, because she didn't even look into it. Slick Nick spoke and she just jumped. That's really what happened. Yeah, okay. All right. Immediately after announcing that Mr. Baldwin had orally moved to withdraw and that Mr. Rosie would be filing a written motion to withdraw, the respondent stated, "I will reach out to public defenders to make that appointment." So she just called a couple of her mates, right? A couple of her mates that she chats with down the pub and whatever. Okay, so it's like swanky dinner parties and all that stuff. She just rang them, do us a favour, come and represent this guy, don't do a decent job, we just need him to be guilty. She just parrots what Slick Nick says. Obviously I'm being a little bit facetious, but you can just imagine, can't you, that kind of conversation behind the scenes may have happened. You know, Slick Nick not prepared for this trial, right? Shitting his pants that the defence are not going to put in for a continuance so he can catch up and try to squirrel into the discovery some more evidence, and realises that this trial is looming and thinks, shit, what am I going to do? Okay. Could we get a leak out there somewhere? Because the investigators have been leaking all sorts of stuff since the early days of this case. Just ask Barbara MacDonald. Maybe go and also ask the murder sheet. Go and put them on oath. Make them swear. Okay. I don't know. Just saying. Just my thoughts. As weird as they are. If no qualified Carroll County attorney was able to take this case, the preferred procedure would have been for the respondent court to contact the state public defender for selection of replacement counsel. So did that happen? Not only would this allow reimbursement in what is likely to be an especially long and expensive proceedings, but it would be also better ensure independence by insulating the selection from the control by the judge presiding over the case. These two attorneys here, like Bernice and her colleague here, know what time it is. They've got the number of this corruption that, in my opinion, appears to be playing out here. Okay, and also the the chief public defender in Allen County. Well, also it affects Allen County as well, because if you don't follow due process, well, the commission might not reimburse them. Okay. She probably thinks that she's got that county, her county, Allen County, under the thumb, and they will, and it'll all be fine. But yeah, all right. Mr. Allen and the public paying for his defence deserve better. As a final point, although this brief focuses on statutes and procedures designed to protect the independence of defence counsel, we should not lose sight of the person most effective. Public defenders do extraordinary, life-changing work every day in courtrooms across the state. Mr. Allen was pleased with the work of his initially appointed public defenders. Mr. Allen and the public that funds his defence should be entitled to more than vague and broad concerns about gross negligence, and that a judge cannot and will not allow these attorneys to represent you. I can't do it, sir. I just can't. Okay. Such statements do not engender confidence in the criminal justice system for criminal defendants, many of whom believe that appointed counsel is not a real lawyer but a public pretender, or a lawyer that works for the state. If I'd ever been defended by Labrato or Scremin, I'd now be wanting an appeal on my case. Just saying, that's what I would want. I'd want a review of my case. When followed, the statutes and decisional laws outlined above provide some means to dispel these misconceptions. When not followed, the trust and rapport developed during a full year of intensive representation is lost, and Mr. Allen is left to wait 9 additional months incarcerated in the Department of Corrections under conditions that he and his counsel of choice, as stated, undermine his ability to prepare his defence. The issues presented in this case justify the intervention of this court at this stage to preserve the independence of defence counsel and the integrity of the public defence structures established by the General Assembly. The court can uphold these essential values by reinstating Mr. Allen's initial and desired counsel. In the alternative, the court should direct the respondent to follow Indiana Code. All right, okay, respectfully submitted, Bernice and Joel. Are you snookered yet, Judge Gull? Are you snookered yet? This is check. Or is it checkmate? You know, the best she could do. You know, they've got till November 16th to respond. The best she could do now is just recuse herself. This could all go away, Francis, if you just recuse yourself and go quietly into the night, just as you thought that Andrew Baldwin and Brad Rosie were going to do. How wrong you were. How wrong you were. All right, guys, let me know your thoughts, and I'll see you in the next video.